Okay, we are ready. Good morning, ladies and gentlemen. Day 2 of our main hearing, and today we will start with the observations by the non-disputing party, the U.S.
I'm not
David?
getting Are you getting anything? Well, you're not getting the sound system.
Okay.
I only hear you in the ceiling.
My mic is on, so it's not on my side.
No. Someone has to turn it on in the back. Okay, I think we got it. No, I'm still not.
Shall I
hearing
give
it.
it a try? Do you get me now?
No, it's not. The interpreter's not getting it either. Okay, now it's on.
It's on? Time.
Yeah.
So,
Thank
once
you.
again, good morning, ladies and gentlemen. Day 2 of
Recording
our
in
main
progress.
hearing. We will start today with the observations to be given by the non-disputing party, the U.S., and may I ask the representative of the U.S. to come closer to us and take the stand there with the microphone.
Good morning, Mr. President, members of the Tribunal. Thank you for giving us this opportunity. Pursuant to Article 10.20.2 of the United States-Colombia Trade Promotion Agreement, or the TPA, I will make a brief submission on behalf of the United States addressing 4 questions of treaty interpretation arising out of the claimant's reply on jurisdiction and merits dated September 19th, 2021, and the respondent's rejoinder on jurisdiction and merits dated February 17th, 2022. As is always the case with our non-disputing party submissions, the United States does not take a position here on how the interpretations offered apply to the facts of the case, and no inference should be drawn from the absence of comment on an issue not addressed. First, I will address the authority of non-disputing party submissions under Article 10.20.2 in interpreting the TPA. Second, I will address the essential security interests exception in Article 22.2, subparagraph B. And third, I will expand on 2 points related to claims for indirect expropriation under Article 10.7. And finally, I will comment on claims based on judicial or administrative adjudicatory proceedings in the context of the submission of a claim under Article 10.16. I would like to begin my remarks by addressing the weight due to the views of the United States on matters addressed in a non-disputing party submission under Article 10.20.2. State parties are well placed to provide authentic interpretations of their treaties, including in proceedings before investor state tribunals like this one. Article 10.20.2 ensures that the non-disputing party to a dispute under the U.S.-Colombia TPA can provide its views on the correct interpretation of the TPA. The TPA parties consider non-disputing party submissions to be an important tool in this respect, and the United States consistently includes non-disputing party provisions in its investment agreements to reinforce the importance of these submissions in the interpretation of the provisions of these agreements. And the United States routinely makes these non-disputing party submissions. Article 31 of the Vienna Convention on the Law of Treaties recognizes the important role the state parties play in the interpretation of their agreements. And although the United States is not a party to the Vienna Convention, we consider that Article 31 reflects customary international law on treaty interpretation. Article 31, paragraph 3 states that in interpreting a treaty, and I quote, "there shall be taken into account, together with the context, A, any subsequent agreement between the parties regarding the interpretation of the treaty or application of its provisions, and B, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation, end quote. So Article 31 is framed in mandatory terms. It is unequivocal that subsequent agreements between the parties and subsequent practice of the parties shall be taken into account. First, where the submissions of the TPA parties demonstrate that they agree on the proper interpretation of a given provision, the tribunal must, in accordance with Article 31(3)(a), take this subsequent agreement into account. And second, the TPA parties' concordant interpretations may also constitute subsequent practice under Article 31(3)(b). Any suggestion that non-disputing party submissions are not entitled to deference because they are made in the course of the arbitration should be rejected. The TPA parties expressly included the mechanism to provide interpretations of treaty provisions to investor state tribunals in the course of an arbitration for a reason. Indeed, the International Law Commission has commented that subsequent practice may include statements in the course of a legal dispute. Accordingly, where the TPA parties' submissions in an arbitration evidence their common understanding of a given provision, this constitutes subsequent practice that must be taken into account by the tribunal under Article 31(3)(b). Additionally, in support of this general position, we note that investment tribunals constituted under the NAFTA have considered this issue and have agreed that submissions by the NAFTA parties in arbitrations under Chapter 11, including non-disputing party submissions, may serve to form subsequent practice. For example, the Mobile versus Canada Tribunal found that arbitral submissions by the NAFTA parties constituted subsequent practice and observe, and I quote, "The subsequent practice of the parties to a treaty, if it establishes the agreement of the parties regarding the interpretation of the treaty, is entitled to be accorded considerable weight," end quote. And I'm quoting from paragraph 158 of the Mobile versus Canada decision on jurisdiction and admissibility, dated July 13th, 2018. And I would point you also to paragraphs 103, 104, and 158 to 160 for context. The Tribunal and Canadian Cattlemen for Fair Trade reached a similar conclusion at paragraphs 188 to 189 of its award on jurisdiction, dated January 28th, 2008. I would note also, in response to comments on this issue, that TPA Article 10.22.3, which concerns interpretations by the Free Trade Commission, and Article 10.20.2, which concerns non-disputing party submissions, merely establish separate mechanisms for the parties to provide interpretations of their treaty. Nothing in the TPA text suggests that in granting the Free Trade Commission the ability to issue binding, authoritative interpretations of the TPA, the parties intended to preclude themselves from issuing non-binding, but nevertheless authentic, means of interpretation of TPA provisions through their submissions to investor state tribunals, or to preclude a tribunal from giving such submissions the weight to which they would otherwise be entitled. So to sum up this point, whether the tribunal considers the interpretations presented by the TPA parties as a subsequent agreement under Article 31(3)(a, as subsequent practice under Article 31(3)(b, or both, on any particular provision, the outcome is the same. The tribunal must take the TPA parties' common understanding of the provisions of their treaty into account. Second, I would like to address the essential security interests exception in Article 22.2b. The language of Article 22.2b is clear, that the exception is self-judging. Article 22.2b states, and I quote, "Nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary for the protection of its own essential security interests," end quote. The ordinary meaning of the word considers is to come to judge or classify. Under Article 22.2b, what must be considered or judged or classified is whether the relevant measure is necessary to protect the state's essential security interests. That this determination is made solely by the state party itself is plain by the use of the word it preceding considers. Thus, the ordinary meaning of the phrase "it considers" is that the exception is for the party itself to determine, or in other words, that the exception is self-judging. That Article 22.b is self-judging accords with the long-standing U.S. position that similarly worded essential security interest exceptions in U.S. agreements are to be read as self-judging. Indeed, footnote 2 clarifies that, and I quote, "If a party invokes Article 22.2 in an arbitral proceeding initiated under Chapter 10 or Chapter 21, the tribunal or panel hearing the matter shall find that the exception applies," end quote. In other words, once a state party to the TPA raises the exception, its invocation is non-justiciable, and a Chapter 10 tribunal must find that the exception applies to the dispute before it. Further, footnote 2 to Article 22.2b is prefaced with the phrase "for greater certainty," which in U.S. practice confirms that the self-judging nature and non-justiciability of the essential security interest exception is inherent in the language of the exception itself. As a general practice, the United States uses the words "for greater certainty" in its international trade and investment agreements to introduce confirmation regarding the meaning of the agreement. In other words, the phrase "for greater certainty" signals that the text it introduces reflects the understanding of the United States and the other treaty party or parties of what the provisions of the agreement would mean even if the text following the phrase were absent. As a consequence, "for greater certainty" sentences also serve to spell out more explicitly the proper interpretation or similar provisions mutatis mutandis in other agreements. By explaining that for greater certainty, a tribunal shall find that the essential security interest exception applies where a party has invoked it, the United States signaled its understanding that this is what the essential security interest exception has always required, including in agreements where that "for greater certainty" language is absent. The United States previously explained the use and significance of the "for greater certainty" phrase in other non-disputing party submissions, both written and oral, including in the Alicia Grace and others versus Mexico case, the Legacy Vulcan versus Mexico case, Omega versus Panama case, and Carrizosa versus Colombia case. We would be happy to provide those to the tribunal if that would be helpful. Finally, on this point, I would like to address an argument we heard from claimants yesterday that Article 22.2b merely allows a state to apply or continue to apply measures that it considers necessary for the protection of its own essential security interests, but that Article 22.2b does not address the question of liability or compensation. The United States disagrees. once the essential security interest exception is invoked, a tribunal may not thereafter find the relevant measure in breach of the Chapter 10 obligation, and may not consequently order the payment of any compensation in connection with that measure. Mr. President, members of the tribunal, turning to my third topic, I would like to expand on 2 points that the United States made in its written submission on claims for indirect expropriation under Article 10.7. First is that in the context of an expropriation claim, a substantive element of that claim is that there must exist a permanent deprivation of the relevant investment. For example, the United States agrees with the holding of the oft-cited Burlington Resources versus Ecuador Tribunal that, quote, a state measure constitutes expropriation under the treaty if 1, the measure deprives the investor of his investment, 2, the deprivation is permanent, and 3, the deprivation finds no justification under the police powers doctrine, end quote. Conversely, it is well established that a temporary, reversible measure leading to an ephemeral deprivation does not result in an expropriation. For example, in Fireman's Fund Insurance Company versus Mexico, the tribunal held that one of the elements of an expropriation is that, quote, the taking must be permanent and not ephemeral or temporary, end quote. Therefore, a non-final determination or a ruling that is subject to challenge cannot cause the kind of permanent and irreversible deprivation that is required as a substantive element of expropriation. Second, as we noted in our written submission, under international law, where an action is a bona fide, non-discriminatory regulation, it will not ordinarily be deemed expropriatory. The disputing parties accept this principle, also commonly called the police powers doctrine. As this is a doctrine recognized by customary international law, any additional elements of the doctrine would have to be established by reference to both state practice and opinio juris. However, while the United States accepts that state practice demonstrates that the police powers doctrine under customary international law is subject to non-discrimination and bona fide limbs, state practice does not support a further requirement of proportionality, as for example between the policy aim and the regulatory measure taken. There is no evidence of the kind of widespread, consistent state practice necessary to conclude that proportionality has crystallized into a component of the police powers doctrine. As reflected in our written submission and in the 2004 and 2012 U.S. model bits, the long-standing U.S. formulation of the test does not include proportionality. And I quote, under international law, where an action is a bona fide, non-discriminatory regulation, it will not ordinarily be deemed expropriatory. The Restatement Third of Foreign Relations of the United States discussion of the police powers doctrine similarly makes no reference to proportionality. So in sum, there is no widespread, consistent state practice that would be necessary to conclude that proportionality has crystallized as a component of the police powers doctrine under customary international law. Finally, I would like to address claims based on judicial or administrative adjudicatory proceedings in the context of submission of a claim under Article 10.16. It is well established that the international responsibility of states may not be invoked with respect to non-final judicial acts unless recourse to further domestic remedies is obviously futile or manifestly ineffective. As the tribunal in Apotex Inc. versus the United States of America held in its award on jurisdiction and admissibility, and I quote, A claimant cannot raise a claim that a judicial act constitutes a breach of international law without first proceeding through the judicial system that it purports to challenge, and thereby allowing the system an opportunity to correct itself. As such, non-final judicial acts cannot be the basis for claims under Chapter 10 of the U.S. Colombia TPA unless recourse to further domestic remedies is obviously futile or manifestly ineffective. Rather, an act of a domestic court or an administrative tribunal that remains subject to appeal has not ripened into the type of final act that is sufficiently definite to implicate state responsibility, unless such recourse is obviously futile or manifestly ineffective. Thus, absent finality, no claim based on judicial or administrative adjudicatory proceedings may be submitted under Article 10.16 unless further recourse is obviously futile or manifestly ineffective. In concluding, I would just emphasize that the United States stands by the interpretation set forth in our written submission, although we did not address all of those issues today. Mr. President, members of the Tribunal, with that final observation, I will close my remarks. I thank the Tribunal for this opportunity to present the views of the United States on these important interpretive issues.
Thank you very much. Do we have questions? Thank you very much. You are now released. You may stay in the room or leave, and we will now start with the examination of sorry, am I wrong?
Yeah, no, I think that we had scheduled 10 minutes, the opportunity
Okay.
for the parties
Yes,
to
so please,
comment.
for the preparation of the witness testimony with a short break. Yes?
No.
Sorry. Oh, okay, yes, I'm sorry. We were to allow you to make comments in respect of the observations of the United States. I overlooked that. We will start with the claimant.
May I ask a question, since I'm taking the time? This 10 minutes that we had foreseen as maximum for the parties to comment, is that time, should I discount it from the total 16 hours, or should I add it as extra 10 minutes?
Added as extra.
Extra,
Yes.
thank you.
Did you wish to have a short break in order to
Actually,
prepare your comments?
Would it be okay to have maybe 2 to 5 minutes if that's
5
okay?
minutes is okay. I think that's fair enough.
Maybe it's slightly more so that we can go and consult rather than staying in the room.
Yes, because experience shows that 5 minutes is never 5 minutes. So,
That's fair enough.
so what shall we say? 15 minutes?
Oh,
Is that too long?
that's fine.
That's
10
fine. 15 minutes.
10,
Yeah.
15 minutes, sure.
So
Thank
let's
you.
resume at 5 past 10. Okay.
Thank you.
David, Leandro? Okay, good. Clement, we give you the floor.
Thank you, President Sachs. It was indeed a productive 15 minutes. Thank you for that. We did have some sense as of what might be coming this morning, so we did prepare a few slides for your benefit. A couple of things that we just wanted to point out for the tribunal. They will no doubt be aware of this, but first of all, the Colombia and the United States in their treaty, as mentioned this morning by Ms. Grosch, did specifically provide for a free trade commission process where if there was to be anything that is an interpretation that was, and you can see on with the language, 10.2.2.3, if they wanted an interpretation to be binding on a tribunal, then they have a process that they go through the Free Trade Commission to issue the interpretations of the provisions of this agreement. In 20.1, the Free Trade Commission has that process. It says the Commission may, among other things, issue interpretations of the provisions of this agreement. They have not done that with respect to this agreement, of course, and so there is no binding interpretation of any of the provisions you heard about. If you look at slide 3, which is up on the screen here, you can see that the parties have indeed entered into specific interpretations of provisions, and none of them relate to Chapter 10. The Renko versus Peru Tribunal, I think this is a helpful quote. Even if there is a subsequent agreement, which we don't know what precisely that agreement is, and that's part of the problem. When you have an agreement, the reason why the Free Trade Commission process is usually followed is because then you have two parties agreeing to specific language, signing off on it, and you know precisely what the agreement is. There's certainty. The tribunal can take that into account. But even if you do say there's an agreement here, the Renko versus Peru Tribunal made it clear that in accordance with Article 31 of the Vienna Convention on the Law of Treaties, the tribunal is not bound by the views of either state party, although the tribunal may take into account any subsequent agreement.
Must take into account.
Sorry, yes, must take into account any subsequent agreement between the state parties pursuant to Article 31.3a of the VCLT, the proper interpretation and how it should be applied to the facts of this case are tasks which reside exclusively with this tribunal. And with respect to the essential security provision in particular, we've given you our interpretation of this yesterday. One must start with the ordinary meaning under Article 31, and the ordinary meaning of the word preclude, according to the Oxford English Dictionary, is to make impossible, to prevent from happening. That's the ordinary meaning of the word preclude. Allowing compensation to be paid does not preclude a party from applying measures. That's our position, and that was the very same argument in front of the Eco Oro Tribunal in interpreting a very similar provision, where the Canadian government came in and made a non-disputing party submission to agree with Colombia. And there, if you look on the next slide at paragraph 836, the tribunal specifically said, whilst the tribunal accepts that the state cannot be prohibited from adopting, enforcing an environmental measure in accordance with Article 2201(3), it cannot accept Canada's statement that in such circumstances, payment of compensation is not required. Canada came in and made the exact same argument you heard the US government make this morning. This does not comport with the ordinary meaning of the article when construed in the context of the FTA as a whole, and specifically in the context of Chapter 8 as analyzed in the preceding paragraphs. So again, in that case, you had a very similar situation to what you have here. You had Canada and Colombia articulating the very same argument that precluding meant you can't pay compensation. And in that treaty, you can see that the language is adopting or enforcing measures necessary. The agreement shall not be construed to prevent. So instead of the word preclude, they use the word prevent. We would say very similar words. A party from adopting or enforcing a measure necessary, in that case, to protect the environment. And that's the conclusion that the tribunal came to after considering the Canadian government submission. Interestingly, what you did not hear from the US government submission this morning is whether or not this provision was subject to a good faith criteria. And the reason why you didn't hear anything from the US government on this point is because Colombia has already made a statement in their rejoinder on precisely this point. This seemed to be an alternative argument yesterday, but it's not an alternative argument in their rejoinder. In the rejoinder, the respondent said as follows, you can see it on the screen, paragraph 43. It is the respondent's submission that the tribunal's scope for review of Colombia's invocation of the exception is strictly circumscribed to an examination of whether the exception has been invoked in good faith. So they accept that there is still a good faith overlay. This is separate and apart from the argument I've just made about allowing compensation no matter what. And what is that good faith overlay? Well, it's a two-part test according to the Russia measures concerning tariff and, traffic in transit WTO panel. What they said, it was a two-part test. The first relates to the definition of the essential security interest. Have they defined the essential security interest in good faith? And the second relates to whether the measures at issue meet a minimum requirement of plausibility in relation to the proffered essential security interest. Now, you've already heard me on the first point yesterday, so I won't belabor the point, but by simply recasting a public purpose originally articulated in their counter memorial as now an essential security interest, we believe is not in good faith. But more importantly, and I think this is clear, and you did not hear anything from the US government on this morning, is at what point in time must the essential security interest be identified? You did not hear anything about this, despite our submissions about this point yesterday, because it is crystal clear from the text of the provision that that essential security interest must be defined at the time the measure is taken. Of course, that seems obvious. The language itself says to preclude a party from applying measures it considers necessary for the protection of its essential security interest. If you are taking a measure to protect your security interest, you must articulate that essential security interest at the time of taking the measure. How do we know that didn't happen here in this case? One, they didn't say so in their counter memorial. If they would have taken this measure to protect an essential security interest, they would have known it in their counter memorial. That's, by the way, exactly the position in the Nicaragua versus US case before the ICJ, where the court considered a very similar question. And they said the chronological sequence of events was important. They must have been, at the time they were taken, measures necessary to protect its essential security interests. And what is the position? They confirmed it yesterday. Colombia said yesterday it was new facts and circumstances that prompted the invocation of the essential security interest. This is from their slide yesterday. They're saying it's new facts. It's not back then what happened. It's new facts and circumstances that prompted the invocation of the essential security exception. So they're accepting. It's not something that happened back in 2016. It's new facts and circumstances today that have given rise to the invocation of the essential security interest. So this confirms that the essential security interest is a post hoc manufactured for this arbitration to essentially a get out of jail free card. The last point I want to make is a point that relates to this the good faith exception as well. You cannot articulate a good faith invocation in our submission which contradicts your own law and your own position. We agree with, I think, what the position that the president of the tribunal was taking yesterday, which is, what is this essential security interest? Where is it articulated? And it's articulated in the law. It's reflected in the asset forfeiture law. And Colombia has articulated as to fight against organized crime, money laundering, and drug trafficking, thus ultimately protecting its population from the threats of paramilitary and marginalized groups that have been ravaging the country for years. But its own law accepts that taking assets, taking property from good faith third parties without fault, that is not related. That there is no relationship between doing that and protecting this interest. There is no plausible connection if your own law says we must protect good faith third parties without fault in order to accomplish this essential security interest. We're not going to take assets from good faith third parties without fault. And over the next 2 slides, you see several provisions, Article 3, Article 7, Article 22, Article 87, Article 117, Article 152, all confirming this position. Yes, this is an important essential security interest. We're not saying it's not. What we're saying, or I should make clear, we're not saying that this is not an important public purpose. We don't think it's a properly articulated essential security interest. But what we are saying is that taking things from good faith third parties without fault is not at all related. There's no relationship between that, no plausible relationship between that and accomplishing that essential security interest as reflected in Colombia's own asset forfeiture law. Those are my brief submissions on the expropriation and the other points that were raised by the United States. I think our submissions speak for themselves, so I won't belabor any of those points. Subject to any questions, those are our submissions.
Not at this point of time, Mr. Mulu, thank you. We will now hear Mrs. Bani Fatimi.
Thank you, Mr. President. Unlike Mr. Mulu, I had not anticipated what the U.S. would say, so I do not have any slides to provide, and I will react both to the U.S. government's submissions and to what we just heard. And Mr. Mulu is not addressing some important submissions by the U.S. that I will also address. But generally speaking, and this is not a surprise, that the U.S. is on the same line, is saying exactly the same thing as to how you should read and interpret this provision. And it's not surprising because, as I argued yesterday, we do have the travaux, which will be provided to the tribunal in due course. The only reason why we did not provide it is that the tribunal asked for an index, which will take time, so we will provide that, but you will have that on the record. So it's already there. You already know the intention of the parties, and this is, at least on this self-judging aspect, it's certainly not a surprise. Now, I want to take in sequence what the U.S. Government's position is. I don't have much to say as to the entitlement of the U.S., of course, to make a submission as a non-disputing party. What is important, however, is that it is in the context of an authentic interpretation. This is, I think, what I started yesterday when we were discussing the common understanding of the states. As you know, and I want to refer to 2 provisions. I want to refer first to the Vienna Convention itself, Article 31(3)(a), which the U.S. government has referred to. I quote, on general rule of interpretation, that there shall be taken into account, that's an obligation, there shall be taken into account, together with the context, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. Now, the Vienna Convention does not provide for any requirement of form. It just says subsequent agreement and subsequent practice. So subsequent agreement, you have a bit more clarification in what we are submitting, or if it has not been this morning, you will have it today. It is Exhibit RL 249. This is one of the new legal exhibits. It's the draft conclusions on subsequent agreements and subsequent practice in relation to the interpretation of treaties of 2018. That is the draft conclusions of the International Law Commission at the UN. The conclusions have been adopted by the General Assembly as part of the Commission's report covering the work of its sessions in 2018. And if you look at the conclusions, you will see there's conclusion 3, for example, so it's really focused on subsequent agreements and subsequent practice. Conclusion 3 says, I quote, subsequent agreements and subsequent practice under Article 31, paragraph 3A and B, being objective evidence of the understanding of the parties as to the meaning of the treaty, are authentic means of interpretation in the application of the general rule of interpretation reflected in Article 31. So that's a confirmation that it's an authentic interpretation. Subsequent agreement, it's simply, as the US government has explained, there's a commonality. The two states are telling you, this is our understanding, and both are saying the same thing, and both have the same understanding as to how you should read the essential security exception. You also should look at conclusion 6.2, where precisely the ILC concluded subsequent agreements and subsequent practice under Article 31, paragraph 3 may take a variety of forms. So it can be dissociated. It's not necessary, as Mr. Moulou is saying, that you should have only authentic interpretation as part of the FTC, and that's the only way that this can happen. No, you can have authentic interpretation under international law. It suffices that the two states are providing the same interpretation, and that commonality makes it an authentic interpretation of the treaty. We also have provided in our new legal authorities RL 244, that's a commentary of the 1969 Vienna Convention on the Law of Treaties by Mr. Williger, and I'm quoting, I don't have the page number, I'm happy to provide that later. The parties, quoting, the parties' authentic interpretation of the treaty terms is not only particularly reliable, it's also endowed with binding force. It provides ex hypothesi the correct interpretation among the parties in that it determines which of the various ordinary meanings shall apply. And finally, I would like to refer to Methanex, that's RL 235, where the tribunal, in a final award of 2005, said, I quote, it follows from the wording of Article 31.3a that it is not envisaged that the subsequent agreement need be concluded with the same formal requirement as a treaty, and indeed, were this to be the case, the provision would be aetios. So this is first to say that there's no formality required. Authentic interpretation means simply there's a subsequent agreement between the two states as to what the agreement means. The US government specifically referred, and Mr. Moulou wants to ignore it, to Article 1022.3 of the TPA, where the US government took the position that's a binding authentic authority under this provision. It does not mean that the governments cannot otherwise have an authentic interpretation if they have a common understanding and they express a common understanding of the treaty, which is the case here. And you have our submission on the meaning of the treaty, and now you have the US's submission on the meaning of the treaty. You will also have the travaux préparatoires, of course. So one does not exclude the other, and by the way, incidentally, that provision is in the provision called governing law, so it is something that does not mean that other types of authentic interpretation are not possible. I want to go now to, just very briefly, because we argued it yesterday, what actually the international security exception means. And simply this is exactly the point where there's a identical, I should not even say common, there's an identical understanding by the US and by Colombia as to how this provision should be read. And again, you will have also travaux préparatoires which will confirm that and will confirm the self-judging nature of the provision that you will see in the travaux. I want to address briefly a few points that Mr. Moulou made on the timing of the measure, which supposedly the US government did not address, and I think there's a reason for that, but the US government actually did address it. You have just to understand what the submission we heard earlier means. First of all, I want to make a sort of a parenthesis on the time and to remind the tribunal what our position is. First of all, it's reducing our position to the law. We're not saying that the measures are the law. We're saying that the measures are the law on asset forfeiture, the measures that the government, Colombia has taken in relation to the meritage, so the ongoing asset forfeiture proceedings, the ongoing criminal investigations. I argued that yesterday. So the measures are all of those. And you remember there's a broad meaning of measures in the TPA. So all of those are measures. There is no time limit. I argued that yesterday. The TPA Article 1022 does not impose any time limit. There is no waiver. So states have the ability to raise the exception whenever they consider that their national interest, their essential security interest, is at stake. That's a determination for the states to do, both Colombia and the US, in their common understanding of this provision. So, and I also remind you, Mr. Mulu kindly referred us to Colombian law. If anything, this shows one thing, is that Colombia is governed by the rule of law. Colombian courts are governed by the rule of law. There are processes, there are guarantees, and there also are the guarantees of the Constitution, and the Constitution itself, and that's also part of the regulatory framework that we're talking about here. Article 34 of the Constitution, which I relied on yesterday, does make a distinction between asset forfeiture and confiscation. It's not the same thing. Why? And that now is something that the US argued, and I will come back to that very briefly, is because it's not a final decision. It's not a final court decision. You are sitting in a case where it simply is not ripe. Nothing is ripe. No final decision has been made in that regard. Now, coming back to the timing and the good faith. So Mr. Mulu is taking issue. The US government is not saying if it has to be determined in good faith or not. Remember, when we argued the good faith, that's in the alternative. Should the tribunal not find that this is self-judging, which it should, now you are faced with an authentic interpretation by the two state parties to the TPA, which say this is self-judging. And the US government has given meat to that. What this means, and again the Travaux will give some more meat to that as well, the US government is saying non-justiciable. We actually refer to that concept in our written pleadings. Justiciability is, we said yesterday, I argued jurisdiction. Jurisdiction is the technical word to say that you do not have jurisdiction to determine and to actually looking at the criteria and determining whether or not you have jurisdiction. Justiciability is above that. Justiciability is as just like arbitrability, but in the international law world. It means that you do not have the power. It's a question of power. It's not even a question of jurisdiction. You do not have the power because if the states say this is outside the scope of what you can do, this is not justiciable, and therefore it cannot be adjudicated at all. So this is the concept that we heard. This is certainly the way that Colombia understands it as well. Now we can translate it into also jurisdiction, but the simple matter is that it is self-judging, therefore you cannot adjudicate that. And the consequence is that, and we agree with respect, but this is also what I argued yesterday, that once the exception is raised, the tribunal cannot find the measures to be in breach and cannot, as a consequence, grant compensation, because compensation is the only consequence of a finding of breach and responsibility under international law. And the US government specifically said this morning, and you heard it, that the interpretation provided by the claimants is wrong. So the US government, I think, knows what the US government meant when the US government entered into this treaty with Colombia, and so did Colombia. Now, on the indirect expropriation, I just refer the tribunal to our submissions. Here again, there's a common understanding that there's no final determination subject to challenge. If there's no final determination and the measures are subject to challenge, simply there cannot be an expropriation, and also the no requirement of proportionality. I refer the tribunal back to our submissions. And also my final point is, my final point is that, and this is what I argued all along yesterday, and the US government here today referred to Article 1016, I believe. You are here present with non-final judicial acts. It is not final. The Colombian courts are working. The Colombian courts are looking at these issues, which Colombia has determined to be its essential security. So now, leaving aside essential security, simply this is not ripe. You cannot make any determination because it's all before the Colombian courts, and they will determine in the future whether or not there has been the Newport, which is now an affected party, is a bona fide, without fault, third party. One final word, because I forgot it earlier. Mr. Mulu referred to Eco-Oro, still on essential security, and here I'm looking at his slide, and he says it's a similar, if you look at, I don't think I have a number for the slide. If you look at the slide on Eco-Oro with the Canada-Colombia FTA, with respect, this is not a similar provision at all. Mr. Mulu says it's a similar provision, very similar. It's not similar, you just look at it. It says, on top of the page, it says Canada, Colombia FTA, Article 22013, for the purpose of Chapter 8, investment. So it's an actual provision for the purpose of the investment chapter. And then you have a number of requirements, which is the measures are not arbitrary or unjustifiable, they're not disguised restriction of international trade, and then you have the list that you have also in the GATT Article 21, which I argued yesterday. So this is anything but a similar provision to what you have in front of you in the TPA, because that is a provision that is at the end of the treaty, and you remember the context, that says nothing in this agreement, so it captures the entirety of the treaty. And again, the travaux préparatoires, you will see, say that it's the whole treaty that is trumped, and it's enough for the states to raise and to invoke, and that invocation is not justiciable, to invoke the exception for the tribunal to not be in a position to find that the measures are in breach. So whatever the Equatorial Tribunal found was based on a very different provision. So the analogy, again, does not work at all. I had said that yesterday. Mr. Mulu goes back to it. I'm not sure why, but you just have to look at the actual text and what the actual text says and how it's interpreted by the Equatorial Tribunal. I think I'm exhausting my time, so I will stop here. Thank you very much.
Thank you very much. Ola, do you have a question? Okay. To hear you, Mr. Seda, as witness, would you kindly take a seat?
Can we pause for just 2 minutes?
Yes.
Thank you.
So are we ready to resume? So good morning once again, Mr. Seda. In front of you is a declaration that we would ask you to read for the record loud.
Good morning. I, Angel Seda, solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Seda. You submitted in these proceedings 3 witness statements. The first one dated 15 June 2020, the second 7 September 21, and more recently a third one on April 25. Is there anything in any of these 3 witness statements that you would wish to correct at this point of time?
No.
Thank you. Then there will be direct, limited as we have agreed to the contents of the 3 witness statements.
We will keep it very brief, Mr. President. I just want to confirm, Mr. Seda, that you have your 3 witness statements in front of you and also a binder of exhibits that was provided.
I have my 3 witness statements. I do not see a binder of exhibits.
Okay, we're, in fact, unless you, I think you have no corrections as you've confirmed for the President, so there's nothing further from us.
Thank you very much. May I, Mr. President?
Yes, you may now proceed to cross-examination.
Thank you. Good morning, Mr. Seda.
Good morning.
Nice to meet you. I've seen your name a lot.
I'm sorry?
I've seen your name a lot. It's good to meet you in person.
Likewise.
Thank you. So I'm Yasbani Fatimi, as you know. I will ask you questions on behalf of Colombia today. We are going to actually give you the binder of exhibits. I'm sorry? So there's one binder that we have prepared. Can you please provide that to the witness? And Mr. President, we also have prepared one version for you. I think that you prefer to have a paper version. So I will take you through this binder. I will give you the tab numbers, of course, and you should feel free to look at the documents, and you probably are familiar with them, but take your time to provide. And just for the record, we also have, of course, the electronic bundle that we will be using on screen, and as the witness and the chair will be following, I guess, on paper, we will be, the rest of us are going to follow on screen. So, Mr. Seda, the binder actually also includes your witness statements, but please feel free to use those that are in front of you. So I will start with your first statement, paragraph 10. So this is in relation to arrival in Medellin, right? In July 2007, this is the start of your adventure in Colombia, right?
Yeah, correct.
Can you confirm to me that you speak Spanish?
Yes, I speak Spanish.
Fluently?
I mean, that's opinion, but yeah, sure, I think I do.
Okay. So if we look at what you say at paragraph 10, and just read it for the record, in July 2007, I arrived in Medellin. I soon recognized that it was ideal for the type of project I was considering. The civil war that had ravaged Colombia finally appeared to be coming to an end, and the newfound peace was generating new economic opportunities. And then refer to then President Uribe. So there had been a civil war ravaging Colombia, right?
Yeah, I don't think that's in denial. I understood that from popular cinema and movies and TV shows. Yes.
Right. And it was ongoing, the civil war, back then.
Can I add context to my answer?
Of course, but please answer my question first, and then you can provide
Okay.
context.
I did not believe it was ongoing. If I had believed it was still the same it was before, I wouldn't have gone to Colombia. I thought that Colombia was at a different point in stage in its history. Part of the reason why I decided to go to Colombia was reading an interesting article called Extreme Investing in Colombia, and they talked about the dramatic changes, 95% decrease in assassinations and over 96% decrease in kidnappings. So I thought that the country was a different country.
Back then in 2007, when you arrived in Medellin.
Correct.
But the civil war was ongoing, wasn't it?
That there was still violence in the country, yes, but it was, in my opinion, a mere afterthought of what it was before. I believe the death toll per 100,000 was over 387, and it had dropped to, I believe, 24 per 100,000 when I arrived. That was extremely positive. I saw it as a new country, a rebirth country. I was very excited about that.
Yeah, I understand that. You still are not answering my question. The civil war was ongoing, wasn't it?
I'm giving you my opinion. In my opinion, it was not.
It's not an opinion. Do you know if the civil war was ongoing, yes or no? If you don't know, you don't know.
I don't know. I'm not a professional enough to be able to opine on that.
And do you remember you were in Colombia then in 2016? That was when the peace agreement was signed between the government and the FARC, right?
I don't know the exact year, but I would say yes, a few years ago.
Yeah. So looking at some of you refer and rely a lot on press. So this is one, tab 9 of your binder. That is Exhibit C09 bis. It's an article from the Telegraph.
I'm sorry, what was that again?
Tab 9. Look
I'm
at
on
tab 9.
Yeah.
So I'm just giving it for the record. This Exhibit C is your exhibit, Exhibit C09. And this refers, just looking at the first two paragraphs, it refers to 25 years ago. Time magazine dubbed Colombia's Medellin the most dangerous city on earth. And then the next paragraph, it says, and this is dated 2008, by the way. It's the date of this article is 4 January 2018. So even 10 years ago, that means 2008, Medellin was a badass town, violence reigned, civil society had been destroyed, and no one seemed to know how to put Medellin back together again. This is 1 year after you arrived in Medellin for your investment, correct?
I'm sorry, let me read the article. I want to understand it completely. Is that okay?
It's okay, but if you're going to read the entire article every time,
No, just
these are long documents, and I'm sure you're familiar with them, so
just
please
to
take
get a
your
little
time.
context before and
Of
after.
course.
Thank you. And I'm sorry, I don't see the date on this article. What was it?
I do not see it on the article itself, but it is dated for January. It's your own exhibit, so it was provided to us with that date, 4 January 2018.
I just want to make sure, I'm not trying to obstruct, but I just want to make sure that the date that you're referring to isn't the date we submitted, but rather the date the article was published. That's it.
It is the date of the article. This is your exhibit. Your exhibit, as provided, was provided with the date of 4 January 2018 for this article.
Okay. I arrived in Colombia in 2007, and I would not characterize the city the way they're characterizing it here. Again, 24 murders per 100,000 in what used to be the murder capital of the world. I've compared those numbers to numbers of U.S. cities. That's not a characterization violence reigned and civil society had been destroyed. That is not what I experience on a personal basis, living in Colombia and raising children in Colombia. That's not what Medellin was.
We're talking about 2008, so that was 1 year after you arrived. We're not talking about today. We're talking about back then. And this article says even 10 years ago, in 2018. So you just don't agree that violence continued to reign and the civil society had been destroyed?
Well, I believe the numbers, statistics in Colombia speak differently. In 2008, violence was very low. In 2008, kidnapping was nothing of what it was in the 90s.
Yeah,
So-
it was no longer Pablo Escobar, but it was still Medellin with a lot of violence and civil war still, correct?
I'm simply giving you the numbers, the data. The data doesn't support what I think
I
you're
don't
trying
have
to
those data. I
contextualize.
don't know what data you're talking about. I'm asking about whether you know that this was still, and this is your own exhibit, violence reigning and civil society destroying. If you do not agree, I move on.
Yeah, I don't agree.
Okay, you do not agree with your own exhibit. So then let's look at tab 10. And this is also your exhibit. The article itself is dated 9 May 2013, as you can see on it. You see that? So that talks about luxury living in a bucolic shoreline setting in Colombia. If you look at the third page of the document, you see page 3 or 4, you see in the middle there's a paragraph that my colleague will now highlight. Mr. Seda conceded that many of his regular investors based in the US were spooked by the idea of putting money into Colombian real estate, particularly those who remembered the 1980s and early 90s when Medellin in particular was dominated by violent drug gangs. So this is, of course, a background against which you are investing in Colombia and proposing investments to partners, right?
Well, I believe what it expresses is the previous history. And I believe that my investor's concern is the present, or is the past history, does that show at all what the present is? And my ability to gain their confidence and give them a surety that was not the case was to invite them to Colombia. And all of my investors took their time and came to Colombia and were able to see that that wasn't the case. That it was a very different city than what the past was.
So you're saying after you arrived in Colombia in 2008, it was paradise?
For me, it pretty much was.
For you
Yes.
personally, but was it paradise for the people living in Medellin and being killed by the drug gangs?
I think it's paradise for the Colombian people. I believe they love the place they live in. It is a very desirable place to live and raise a family. It's a great place.
Talk about Medellin.
I live in Medellin.
Yeah.
I'm talking about Medellin as well.
Yeah, and at the time there was no violence, no issue of drug trafficking, no cartel issues, nothing.
Well, I believe there's violence in all cities around the world, and I was comparing Medellin's security state and Medellin's general situation to other metropolitan cities. I believe there's violence. I believe there's drug trafficking. I believe there's all this happens in every single city. I don't think Washington, D.C. or New York or Miami or Los Angeles are immune to any of the things that you're talking about. But there was huge opportunity. Yeah, so I believe that there's, again, violence in communities around the world. I believe that there's violence between those factions that you're talking about. I'm not an expert. I can't begin to opine on the inner workings of La Oficina Envigado. I'm not that well versed on it. I just know that in general, from a general perspective, Medellin is a great city. Medellin compares to a lot of U.S. cities when it comes to violence. Again, U.S. cities, European cities, Asian cities, or cities in Asia, they all suffer from similar issues.
And we agree that the U.S. investors were concerned, to say the least, with the perception of violence, at the very least, if that's a perception, as you say.
I believe anyone who had not visited Colombia would not be smart to be concerned. And until you put boots on the ground, and I do that with every investor that we have, I don't think it's responsible to accept investment from investors who haven't put their eyes on exactly what it is that you're talking about. What's the concept? What's the vision? What's the plan? And so I invite all my investors to do that. And upon them arriving to Colombia, arriving to Medellin, as discussed with them, they saw exactly what I saw.
Okay, let's see what you did there. So I'm now looking at your paragraph 15, and you describe your first project, that is the Charlie, right?
Which misstatement are we?
Your first
Okay.
statement? Paragraph 15. You refer to the first project to build a high-end luxury hotel with lifestyle elements in the Lleras Park neighborhood, right? That is in Medellin, right?
That is correct.
And if we look at tab 10, this is exhibit C010 bis. Again. So, and this now on the previous page, page 2, on the top of the page, and it says the Guatape region was one of the country's many rural areas being fought over by leftist guerrillas and rightist paramilitaries during the 90s, but security improved dramatically after President Alvaro Uribe himself, a native of Medellin, took office, right? So this is referring to the fight between leftist guerrillas and the paramilitaries, right, in the 90s. Yeah?
Yeah, the general situation, correct.
And Guatape is where your other project, Luxe, is, right?
Yes, that's correct.
If we can look at exhibit C64 bis, let me give you the tab number. That's tab 11. Do you recognize this document, Mr. Seda?
Yes, I do.
What is it?
It is a investment deck for our Prado Tolima land fund project.
And do you remember the date of this document?
No, the exact date I don't remember.
I'm asking because we don't have a date.
We could get, I mean, like the exact first creation date.
So it's an evolving document, is that what you're saying?
All of our investment decks, for the most part, are evolving documents.
So this version, do you know when it was prepared?
I don't know. This is the
Okay.
first, I mean, I'm looking at it right now.
Let's look at page 18. You have the pages SP on the bottom of the page, SP 18. So you read Spanish, so I will leave it to you to read the Spanish. For the record, I will read a translation. When the plot of land of Luxe was bought in 2009, the region was seen as unstable and dangerous before buyers' confidence. Therefore, buyers' confidence was extremely low. You see that? La región está vista como inestable y peligrosa. You see that?
Yes.
2009.
Yes.
These are your own words.
I would like to give context.
These are your own words that in 2009 the region was dangerous, correct?
No, you're
No?
taking what I statement and miscontextualizing.
It doesn't say what it says?
If you'd like me to add context, I can explain exactly
I
what.
see from now that the entire day you're going to give a lot of context. Please do, but time is scarce, as you know, so.
Okay, understood. And I appreciate it. Thank you. So, the Guatapé region suffered violence, had issues. I believe it was just 2 years prior to this, in 2007 or 2006, the Colombian government made a huge decision, which was monumental for this region, and they added a sub-military base, a special forces sub-military base, just about 3 kilometers away from where our asset is. Because of the violence that had happened previously, you couldn't visit this area without being stopped. They would put periodic checkpoints, the guerrilla forces. And so people simply stopped going to this region. They just stopped altogether. And when I arrived in 2007, the military base, the sub-military base had just been installed maybe a year before, if my memory serves me correctly. And I visited the area. I talked to local Colombians, and they all expressed concern about the general region. After further discussing this with them, I realized that none of them had visited this region for, in many cases, 10, 15, 20 years. So even local Colombians, even local people from Medellin really didn't understand the changes that had been made in this beautiful area. So when I'm making this statement, if you see the word vista, era vista, I'm not saying that it was, I'm saying that it was seen. So when you say these are my words that I'm saying this, I just wanted to help you understand that I'm saying this is the way Colombian people view it, not the way that we viewed it. If we had viewed it that way, we wouldn't have bought the asset.
The Colombians are not paranoid, right? If they see a region, here we talk about Guarape, as a unstable and dangerous, very probably it's because there's reason that is dangerous, right?
Very probable that it was dangerous at a period of time and that they have written that area off. It was also used to be a 4-hour to 5-hour drive. Infrastructure changes and improvements changed that to an hour and a half. So what was in the Colombian consumer's mind was this place that is ultra far is what I and I'm saying this as if I was a Colombian. What I as a Colombian remember is 5 hours to arrive there. It was dangerous. There were continuous roadblocks by paramilitary and guerrilla forces, and I haven't been there for 15 or 20 years. Those were the testimony. That's what the testimony that I received from people when I went out into the community and asked their opinion on this region. So that's what I'm trying to say, their viewpoint of it.
I'm not sure when you say you haven't been there for 15, 20 years. The first time you entered Colombia was in 2007, and this refers to a 2009 determination, that in 2009 the region was seen as unstable and dangerous.
I had just said that I was expressing this as if I was a Colombian. These were the responses that I was receiving, because whenever we do a project, we go out and we knock on the doors, and what I mean by that is we invite our friends and family and say, we don't blindly do a project. I actually wanted to do this project at the very beginning when I arrived to Colombia in 2007. It was the first project I wanted to do, and at that period of time, we got a lot of negative feedback from local people from Medellin. When we talked to them, we asked them, how do you feel about Guatapé? Even my own partner was like, I don't want to do a project there. People are not going to want to be there. And when we did a roundtable. We asked 20 Colombians, and they all said, I would not buy real estate there. That was their view. Their view was the historic view in the past. And it wasn't the reality of what was happening at the present.
But again, in 2009, there was no civil war, there was no drug trafficking, there was no danger. That's your testimony.
My testimony is that a young American who was 32 years old could go there without armed guards, not be stopped by paramilitary forces, not be stopped by guerrilla, go to restaurants in the region, have fun, buy a piece of property, and never experience any issues. That to me is safety.
Yeah, you got lucky. Let's look at how you did this now. Still the same document, page 9. So I'm looking at the second paragraph, and I will read for the record an English translation. So RPG is Real Property Group, right? Your group.
Yeah, Real Property Group is my company, correct.
So the RPG has been historically successful in the process of identifying land plots in previously dangerous regions that had stabilized afterwards and now are well valued by the markets. That perception of danger causes prices to be fixed at a bargain, opening the doors to bargaining, a negotiation that seeks to reduce the prices as much as possible. Afterwards, these prices increase rapidly once public perception of the region increases, generating dynamics of purchases and development, right? This is what you started explaining, right? You go and find these nice regions, previously dangerous, and then you just buy a piece of land, right?
Yeah, it's a strategy. It doesn't always have to be danger. It could be other variables, but variables in which a certain area is not attractive for whatever those variables or reasons are. And this is just general real estate cycle. There's something's unattractive. You see promise. You see that there's something that can be made out of it. You are a first arriver. You come in and you create attractive developments, and then usually other people follow. It was our strategy.
And then here you refer to previously identifying land plots in previously dangerous regions, and the perception of danger causes prices to be fixed at the bargain. So you got them at the bargain, very inexpensive, correct?
Well, the perception of danger fixes the prices at whatever the market's going to fix them at.
You say bargain here.
We are looking at what's the potential value could be when you see a beautiful lake and you see beautiful landscape and you see improved security. You're seeing that there's some sort of disparity, that there is that the pricing is not in reality with what has actually happened. And that happens in a lot of businesses. There's a lag between when there's change and when prices actually adjust.
That's not the answer to my question, is it? You are identifying regions that were perceived as previously dangerous. That's what you say. That's not what I say. That's what you say. Identifying land plots in previously dangerous region. The perception of danger causes prices to be fixed at the bargain. That's what you say, correct?
Yes.
You're a very good businessman, Mr. Seda, aren't you?
I hope so.
And those beautiful lands, indeed. Colombia is a wonderful country, absolutely. But you took advantage of the situation and got those lands at the bargain, right?
I took advantage. I thought it was being part of something, of the rebuilding of a country. I didn't think I was taking advantage of the country.
Well, let's look at page 16 of the same document.
Spanish, Tammy, I don't want to interrupt. Is it possible to see the English version as well? Just since we don't have hard copies, it's very hard to follow just the Spanish.
I don't believe there's an English version. Is there?
No, that was your document. And
There-
it was sent
There's
to
no
the
English version?
translator.
Okay.
So it's a courtesy translation I'm giving on the record.
Understood. Thank you.
I'm sorry, Dr. Ponce?
I'm sorry. I was asking if you were saying page 15.
I-16, I'm sorry.
Oh, we've just managed to find the English version, so we're following along now.
Thank you.
There is an English version.
So now looking at the first paragraph, but you have it also on paper if you prefer to look at the paper. You prefer?
I prefer reading it right there.
Okay.
If it doesn't bother anyone,
Okay. No, of course, it's
it's bigger.
your council asked to have a paper binder, so I thought that was your preference. Okay, so I will read slowly for the record the English translation of this first paragraph. Taking into account that the company believes that it can acquire first-class lands costing less than 54,000, which is Colombian pesos, per square meter in the Prado region, Tolima, if one assumes an average sales price of 40,000, again, Colombian pesos, per square meter, the return on the investment has a potential to reach more than 1,000% during the investment phase. So this is what I call being a good businessman, right? You buy a piece of land in regions that are either perceived as previously dangerous or are still dangerous, and you expect to make a very high profit out of it, right? And here you talk about profits of 1,000%.
So when we were doing this pitch deck, or what's called investment resume, we were copy pasting. And what I mean by copy pasting is I felt a little upset that we hadn't done this same thing in the region of Guatapé El Peñol. When we came to the region of Guatapé El Peñol, it's very similar to Prado Tolima. It is a lakefront destination. It is just an hour and a half outside of the city of Medellin, which has a 4 million person population. And the prices of land were somewhat similar. And now I had identified a very similar situation. Beautiful lakefront destination, but now with a population of influence of 10 million people. And it's the city of Bogota, with huge consumer power, spending power. And there was this jewel that no one had done anything with. And exactly how it happened in Guatapé and El Peñol, we purchased the land, we started development on the project. The project did very well, we sold very quickly, and I wanted to kick myself because the land values went up tremendously as a direct consequence of our singular development. Mm-hmm. And so I said, I do not want to make that mistake again. This time, I think it would be smart to acquire land before doing an influential development that will change the landscape and benefit from that. I mean, my job is to give returns to my investors. That's the way I can do what I love.
But again, the business model is that you buy for a pittance, gorgeous regions, pieces of land in gorgeous regions at a very low price. There's the perception of violence, at the very least, if not actual violence. And then you expect a return on investment of 1,000%. This is what you say in your brochure.
So I just want to clarify, we're not taking advantage of anyone. People are...
I'm not saying now.
People,
now my question
please
was...
let me finish.
Now my question was, this is your business model.
Well, you're mischaracterizing my business model. And so I just would like to characterize it in the actual light that it is. Because what it sounds like is you're saying that I'm taking advantage of people, that I'm forcing people to buy. When we come into a region, when we come into an area, we use real estate brokers and we say, these are the characteristics of the assets that we're looking for. Can you help us find properties? And these are willing sellers that say, we want to sell. And we're paying market value. That is, whatever the value is and whatever properties are selling for in that region, in that area, it's not that something is selling for 100 and then we're getting it for 10. If it's selling for 4,000 pesos a meter, then that's the general price in the region, in the area. Consequently, whatever happens to that price after, because we add value, well, those are the fruits of the rewards of business.
Okay. Now, Mr. President, I don't know if you want to have a break now or later, because there was, or do you consider the earlier break to be the morning late break?
Let's have another break, shorter break. Later.
Please continue. We will have another shorter break later.
Okay, thank you,
If
Mr.
you don't
President.
mind.
Of course. So knowing so well the real estate market in Antioquia and Tolima, these are regions where you have invested, right?
I'm sorry, say again? What?
Antioquia and Tolima, these are the regions where you've invested, correct?
Those are some of the regions that we've
Some of
invested
the
in.
regions. So you have in-depth knowledge of the real estate there, right?
I don't invest anywhere that I haven't walked, put boots on and walked the lots we're interested in, walked the entire areas, talked to the mayors, talked to the local councilmen, stayed in the hotels, however good or bad they may be, eaten the food, talked to the neighbors. So yeah, I have pretty in-depth knowledge of anything that we buy. Yes.
Do you call that due diligence?
I would call that due diligence, correct? I would call it due diligence on the land in the sense that where do I think it's going to go? What do I think is going to happen there? What kind of tourism is happening? What's the classification of the tourists? How much are they spending? What do their friends say? Why do people say they don't want to go there? Do they come and go for the day, or they go back, stay the night at a hotel? It's business due diligence with regards to my business model. Yeah.
So it's real estate due diligence, right? So you go to the bottom of things to make sure that what you're buying is something that will give that return on investment that you're hoping, right?
It's business due diligence.
I'm sorry?
It's business due diligence.
Business due diligence, okay. But you are certainly also acquainted with the legal requirements and procedures that apply to real estate, right?
Yes.
And that's the requirements that apply to buying land parcels, right? You're familiar with that?
Yes.
And if I take again your first statement at paragraph 88, this is in another context. This is not the context I'm discussing, but in the context of discussions with Mr. Lopez Vaniga, you refer to having conducted extensive due diligence on page 88. In the middle of the paragraph, you say here, you refer to Newport had transacted in good faith, and extensive due diligence had been done on the property. This included 4 title studies and a certification from the Fiscalia, all of which had concluded that title to the property was clean and free of encumbrances, right? This is your position.
Yes, that's my position.
So, and you refer here to title studies, and one of the title studies is the one that was conducted by the law firm that you commissioned, right? Otero in Palacio, right?
That's correct.
And that you refer to in paragraphs 49 and 50 of your first statement. Here you explain that you, starting at 49, you discuss Cofre Colombiana and the fact that they were you retained them as a fiduciary trust for the project, and that in the middle, Coffee Colombiana asked for a formal title search of the land from a third party to ensure that the title was clear, as I had commissioned similar studies before commencing the Charlie Hotel and Luxe by the Charlie projects. I was familiar with the process. On Coffee Colombiana's recommendation, Newport engaged a well-known local firm, Otero in Palacio, to conduct this study, right? That's what we're talking about. Yes?
I'm sorry, that's what I'm talking about in reference to.
To the titles, one of the title searches that gave you the confidence that everything was fine.
Correct.
And the study that came from Otero in Palacio, as you say, next paragraph, 50, on 7 March 2013, Otero in Palacio issued their study confirming clean title to the property. The title study included checking OFAC and UN sanctions list for all natural and juridical persons that appear in the certificates. Of the properties herein identified, the firm concluded that none of the prior owners of the land were on these lists and identified no other issues with the chain of title. The firm also concluded the corporate study of the seller La Palma Argentina, finding no issues. The firm accordingly gave a favorable rating to the chain of title associated with the land, right? This is the conclusion, right?
I believe that's the conclusion from the title study itself, yeah.
Yeah. Now, if you can look at tab 12 of your binder, this is exhibit C216.
C216.
216.
Correct.
Are you familiar with this document, Mr. Seda?
Vaguely.
Vaguely. So you've seen it.
I think you put this on the screen earlier. Was it today or yesterday? I don't know.
Have you seen it before this hearing?
I've seen so many documents, to be honest with you.
I'm sure.
I'm sorry.
So this is a testimony by your lawyer, then lawyer, Ana Maria Palacio, in the Pinturas Prime arbitration. Can you tell us what that was, that arbitration?
Sure, the arbitration was a legal claim brought by several of the, I think, a unit buyer that had several units who brought a claim against us because they simply said we did not perform on the contract. We had a certain delivery date to turn over the unit, and we weren't able to turn over the finished unit.
So in the context of that arbitration, there's an examination of Ms. Palacio, right? And if I can look first at the first page, which you have in front of you, the very first page, it's called SP0002, in fact. And I'm looking at the last third of the page. Question: what did the title study include? You have mentioned deeds. Does this mean you analyzed the chain of title and the property's prior owners? Would you please explain this issue in detail? And she responds, quote, yes, here's the proposal that was sent to them at the time. I do not know if I may submit it. The proposal talks about doing a title study going back 10 years, a chain of title review going back 10 years for the titles that are included in the property's ownership history. It was also proposed to them that a review be done of lists that are publicly available for all the individuals appearing in the title history for that property. As I said, this verification is done using lists that are publicly available, for example, in Google, in OFAC, perhaps the UN, which deals more with terrorism-related issues, but the search would also be done. Right, so I'll stop here. If you wish to take a bit of time to familiarize yourself with the document, I'm happy to give you a few minutes. With the tribunal's authorization, of course. Yes?
Yes.
So here we see in this excerpt that I read from, Ms. Palacio confirms having looked into 10 years of chain of title. You see that, right?
Yes.
Is that something you knew at the time?
I'm sorry?
Is that something that you knew at the time? She was your lawyer. So did you retain her and say, go back 10 years?
I didn't make it. I wouldn't even know how to tell a professional how to do a title search. I mean, they're the professional. We told them to do what's required. Please do a title search for us.
So she did a 10-year search. That's what you're saying, on her own.
Of course, we said, well, first off, to add context, we asked the fiduciary, which was the fiduciary Corfi Colombiana, part of the largest financial conglomerate in the country, what was the preferred firm. We didn't know Ortero y Palacio. We had never worked with Ortero y Palacio before. I'd never met either Mrs. Ortero or Mrs. Palacio. We simply went off the reference of this huge financial conglomerate and said, who would be the best company to do this title research? Rather than going out and finding a random company, we want the company that you're most comfortable with. And so the financial entity recommended this firm, which was a very highly acclaimed firm. They were working for Colombia and were very well regarded in the community. So we said, great, let's use them.
I did not say that she was not well regarded. I did not take any issue with the law firm. If you listen carefully to my questions and answer my questions, I think this will go faster. So my question was that if you did not tell her to do a 10-year, so it was her own initiative to do 10 years. That was my question. So the answer is yes, I assume.
Yes, I hadn't spoken to her personally.
Somebody for you did in your company. Is that what you're saying?
Correct.
Okay. So let's look at page, bottom of page SP007. And here you see again this paragraph where counsel, cross-examining counsel, is asking Counselor Ana Maria, you mentioned in your narrative that the title studies are for 10 years. Are you able, in your recommendations to the client or in your comments regarding the title study, tell the client or recommend to the client that it be done for more years? And she answers, I quote, yes, it is simply a proposal. If the client says, no, I want you to do the entire chain of recordation of titles, it can be done so it covers the entire chain. So that's her answer. So what this shows is that the title study can carry shorter or longer terms depending on the client asks, right? That's what she says.
So to be clear, on this title study and every title study we've ever performed, we have never, ever directed, suggested, or made reference to a law firm to perform a title study in one way or another. We have always directed the law firm simply, please do whatever's necessary under the law and give us back a fulsome title search.
But what she says here is that she did a 10-year search, and here, in answer to the question, she says that, yes, I can go beyond if the client asks me. The question is, you didn't ask her, right?
To be completely honest with you, in this very moment, I would have no thought process that I would have to ask the most well-regarded title research firm in the state of Antioquia and tell them how to do the work. My assumption is they know what they're doing. I'm relying on their knowledge.
Well, you're familiar with client instructions, right? I mean, clients give instructions to their lawyers. Your lawyers are given instruction by you. My clients are given instruction to me. That's what happens all the time with lawyers.
Well, I can attest to you 100% fact. We gave zero instructions, zero recommendations to Ortero y Palacio on what to do and what not to do with regards to this title search. Our assumption as our reliance was they would do everything that was required under the law to guarantee that we were qualified good faith buyers.
And once you get that title study in hand, you don't question it, you think it's all good. You don't say, maybe I want to look more. You don't have an interaction with them and say, are you sure this is done properly? We're talking about a region that's dangerous with the cartel and so on. You don't ask them.
Of course we do. The same as when people get a second medical opinion. This was one singular piece of our diligence. This gave me comfort, yes. But what really gave me comfort was the combination of this title search, which, as we're referencing, went back 10 years, using Corfi Colombiana, which is a nationally recognized trust fiduciary by the largest financial conglomerate in the country, them going back 60 some odd years, writing the Attorney General's office, getting a certificate that we relied on and felt very proud about when we received it, understanding that Corfi Colombiana is a financially regulated entity that has obviously an approved SARLAF and diligence process. I don't know what it is. I wouldn't even pretend to understand exactly how it works. But our reliance wasn't just on this title search. This was one piece in a very broader spectrum of diligence that we relied on. And this, together with all of the other things that we did, the financial entity that we went to, Banco de Bogotá and Scotiabank, all of them coming back and all saying the same thing. This property's clean, this property's clean, this property's clean, this property's clean. That gave me a huge amount of comfort. Huge amount of comfort.
I was not talking about all of the others. I'm still focused on this one. So in 2013, March 2013, and this particular law firm recommended to you by Corfi Colombiana, they come back, they give you this title study, and you're satisfied with that. That's what you're saying. I didn't want to go beyond. I didn't want to ask them to double check. I was happy with that. That's your answer.
Well, I think what you asked me was, and if I'm right, you said, so you did this title study and you were like, I don't have to do anything else. This is fine. And I'm trying to answer your question.
No, sir, I asked you in relation to this particular study. When your lawyer gives you back the title study, I'm asking you whether you looked beyond this and you asked them, giving instruction, double check, are you certain, and so on, for this particular law firm on this particular title study. Yes or no?
So the thing we've learned, particularly with engineers, for example, if an engineer's bad, you don't ask him to go do more bad work, right? And I'm not saying that they're bad. That's not what I'm saying. I'm saying if you're concerned about are the engineering calculations correct, rather than have the same engineer rerun his calculations, you get a second opinion. You get a new engineering report. And if that second engineering report says, yup, the first guy's engineering looks good, that gives me much more comfort than going to the same guy and saying, can you please rerun this?
Okay, now let's look at other. Actually, no, not yet. I want to finish with this document. Looking at this time the next page, page SP0008. You see on top of the page, starting with second line question, you said that in your title study you had checked 9 deeds, and that basically you, in that 10-year chain of recordation, you stated here that you checked the individuals that appear in the entire record of recordation, in GeoFact lists, Google. Did you also check their legal representatives? She says yes. Question, do you remember having checked or knowing who is the legal representative for Sierra Alta Lopez and Compañía? Answer, yes, it is there. Question, do you remember? Answer, yes. Question, who was it? Answer, Sebastian Lopez. Question, no. And then there's some back and forth about whether it's written and whether she brought the right document. If you go a few lines down, question. So then so he tells her it's Mr. Ivan Lopez, right? When then Mr. Ivan Lopez was the legal representative for that company at that time, she says, I would check. We could check, I'm sorry. I did not bring the attachments. Unfortunately, since the title study was done already some time ago, perhaps the attachments of that for that deed are not among those items, but this person, Ivan Lopez, does not appear on the list that I provided. So issue is taken with the fact that she did not check, or she actually checked legal representatives for Sierra Alta Lopez, and she doesn't recognize that the legal representative is Ivan Lopez, right?
I wasn't present for her testimony. You're discussing minutia within the context of a litigation. I'm not a title study professional. I know that I've looked at the information, and I know that every single owner, everybody that was on title, had been scrubbed. I've went back, I've looked at the documents. I don't know what the methodology is. I understand that there is not a manual written out when it comes to how to do title research, and thus my assumption is that law firms do their title research in the different ways that they do it. I don't know. I can't pretend to know. All I can tell you is that we relied on her work.
So when you say, I know, I'm quoting from you, I know that everything was on title, had been scrubbed and went back, and I looked at the documents. We still don't have the final transfer. I understand that you said that you went back and you looked at every document. Is that what you're saying?
I had my in-house counsel look at it.
Your counsel looked at it, or you looked at it, or both?
My in-house counsel, at one moment in time, I mean, of course, within this long period of time between, let's call it 2016 until today, of course, I've pulled the documents, I've looked at the documents, of course.
At the time, did you double check? Because what she says here is that she checked 9 deeds, right? That's what she did.
That is what it says.
Right. Now let's look at the other title study that you requested in 2016. That's your tab 13, 1-3. Exhibit C 160. So this is another title study that was commissioned by Colpatria for purposes of a loan for the Meritage project, right?
That is correct.
And it was carried out by another law firm, Osorio and Moreno, right?
That is correct.
Do you remember this document?
I do remember this document.
Have you reviewed it for purposes of the hearing?
I've reviewed it in general before the hearing.
Before the hearing? So it is dated 17 May 2016. And if we look at page SP 0014, you see that there's a number of deeds with the dates, right? And if you look at the 3 from the bottom, you see that there's deed 1554, and the date is 12/08/94, right? You familiar
correct.
with that deed? Now, by now, I guess.
I might be vaguely familiar with it.
$1994. So looking at what your other law firm did, so Palacio, that was in March 2013, right? If she did a 10-year search, that would have been from 2013 to 2003, right? So by definition, a deed of 94 she would not have picked.
I would assume it wouldn't hit 1994. Yes.
Right. But these law firm actually did. They went beyond, and you see that you have dates. If you look at the fecha column, you see you have 94, you have 92, number of different dates, right? So if we look at the deed, that's Exhibit R8, tab 14.
Tab.
14, 14.
Uh-huh.
And I have put in the tab both the English and the Spanish version. You're free to look at. Do you prefer to look at the original Spanish?
I'm not that good at looking deeds, but sure. If you'd like to point me to what you'd like me to review.
Well, have you seen this document before, Mr. Seda?
If I've seen it in Spanish.
In Spanish, well, then
but I
let's look at
can't
the
say I'm like
Spanish.
super familiar with it. I mean, is there anything you would like me to review within this document? Oh,
We'll go. I'm just asking if you recognize it.
it looks like a deed.
This particular deed.
Again, I've probably reviewed it.
So it's a. So you see that it's a deed pursuant to which Sierra Alta Lopez y Compañía acquired the Las Palmas lots, right? It's pretty important for you, isn't it? It's the acquisition of the lot which became the Meritage lot, right?
Yeah, I'm going to rely on the fact that
Please, you have the paper
if you say
version.
so, sure.
You have the paper version. Have a look. Take your time to look at it.
That's what it appears to be. Yes.
And if you so you see on top, you see the name. It's going to be highlighted, Sierra Alta Lopez y Compañía. And then if you look at the next page on the B, un lote de terreno situado en el municipal de Enviado, para Las Palmas, not this one. Next page, I'm sorry, the fourth page of the document. You see Presentes, Iván López Vanegas, and you see Representación de la Sociedad Sierra Alta López y Compañía, right?
Correct.
So that's Mr. López Vanegas signing this document, this deed, for Sierra Alta Lopez, right? For the purchase of the land, right?
That is what it appears.
So, this is 1994, had Otero y Palacio gone beyond 10 years, they would have found this deed, right?
I'm sorry, they would have what?
Found, they would have identified this deed.
So, for example, if they had gone to 20 years, I don't know how many years they would have gone back. But for example, if
For
they had gone
example,
to
20
20 years,
Yeah.
my assumption is that they would find the seed potentially.
So, looking back at Exhibit 160, that is tab 13, 13 again. I'm looking at the last page,
Oh, sorry.
tab 13.
SP001. Oh, I'm in the wrong place. Sorry.
C160, tab 13, last page, SP0015.
Yes.
And you see there's a disclaimer there, right?
What are you referencing?
The concepto. So looking at the last page, concept,
okay,
right?
yeah.
So you have the English version. This study was performed based on the information provided up until today. Dos Osorio and Moreno Abogados, are not liable for any information that may appear thereafter that up to date is not known by this lawyer office, such as information regarding assets for future processes where such change has not been recorded within the registration page reviewed. So this is the second law firm that has gone actually to over to 20 years, identified, as we have seen, the deed 1554, and they say that this is the disclaimer they don't take responsibility for information regarding assets for future procedures, right? That's their disclaimer. And those that are not recorded, that's to be precise what they say.
I mean, this is, I believe, to be a rubber stamp. I mean, with regards to, Osorio Moreno's doing a title search for a national bank. Who contracted her was Scotiabank, not us. We hadn't even been privy to this title search until months after we had already closed the loan with Banco de Bogotá. She's affirming in this title search that there's no issues, and if you look at the findings, that there are no issues with the title, including the deed that you're referencing, including the individual that you're referencing. So in our conversations with her, she stipulated that she had looked at that deed and looked at this person on the OFAC list and the UN list and all the essential lists.
That's not what she says, is it? The study was performed based on information provided up until today. That's 2016, right?
Well,
And the firm are not liable for any information that may appear thereafter that up to date is not known by this lawyer's office, such as information regarding assets for future proceedings. Right?
can we see the Spanish version, please?
Sure. I think you have it in the binder.
Where would it be located?
Same tab. You don't have it in the same tab?
I have it now. So if you look at SP-0013, C-160.
What SP page are you referring to?
SP-0013.
Okay.
And I will read this to you and then give you the exact context of which our conversation was directly with the creator of this title study. Okay? And it says, de acuerdo con la documentación aportada, el inmueble objeto del estudio se encuentra, and it's capitalized, libre de todo grave y limitación al derecho de dominio. And I will translate that to you for what we understand in Colombia. It means that the property has no issues whatsoever. This is the equivalent of a positive finding in a title study. Okay? And then furthermore, the reason why we added this, where you're getting this document, and unfortunately the date isn't completely correct, because this document was given to Scotiabank at the end of 2015. She reproduced this document for us to be able to add into our legal claim in response to Ivan Lopez's tutela. Okay, and the reason why we added it was because she says we came to a completely favorable finding when Scotiabank ran this. We came to a completely favorable finding on the 20-year history of this title. We were happy about that. We felt it showed clearly that there were no issues with the title. We made copies of it. We added it into our filing, and we sent it to the courts in our response to Ivan Lopez's tutela.
So that was not my question, but since you're discussing this, the actual translation is that it's free of attachments. Since I'm not a native speaker, I'm asking my partner, the lot is free of liens or attachments over the title. That's what it says.
You have to finish the sentence. So if you look at
But
the end,
that's what it says. I mean, I'm correct in your translation now.
well,
It is free of liens or attachments over the title.
limitación al derecho de dominio,
Okay.
the
but-
right of title. Derecho, the right of title.
So,
That is the equivalent of a favorable finding. If it was an unfavorable finding, you would see it in bold, and they would specifically stipulate this is an unfavorable finding, and they would say this individual, title number, whatever, the escritura that you're referencing. And again, I'm not a professional. I don't know exactly how this works, but they would say, this individual, we found them on the OFAC list. Our recommendation is that's not favorable, should not proceed for acquisition of the property.
and
or
now
lending.
if you go back to the last page, which is the disclaimer, which is what I was discussing with you, it is the disclaimer regarding for future proceedings not yet recording on the deed of title. So if it's not recorded, they cannot know it, right? So that's a disclaimer. They say what they can say based on the information that they find, but they are making a very clear disclaimer, right? I'm just talking about disclaimers. You know what a disclaimer is.
I do know what a disclaimer is.
You're familiar with disclaimers. You said that earlier.
Yes.
Okay. Can we say another disclaimer?
Sure.
Excuse me for the interruption. This is for the benefit of the interpreters. When you switch from one language to the other, if you could please make sure to wait a few seconds so that they have time to switch from one channel to the other. Thanks.
Of course, apologies.
And we should now consider soon to have our morning break. But you're still on the document, or are the?
No, I'm moving to another document, so we
Okay,
can have
okay.
a break now. if you
I
wish.
would still have a question relating to this document. I see in the English version on page SP-0013, chapter 3, prior titles, and when I compare the titles mentioned here with the titles documents studied under paragraph 5 on the next page, not all of the document studies, of the deed studies mentioned on page 0014 appear here under the title prior titles, and I also see that in the second paragraph of that section 3 at the very end, when they talk about the deed number 3338, they add, thus it's been more than 10 years since. Do you have an explanation why they are mentioning the 10 years in this context here?
I can give you context and conversations that I've had with title study professionals, and
at the
particularly
time,
with,
or
with
at the time? When-
at the time of
Okay,
when we
yeah, yes, please,
when we
yes.
recovered this title study, because
Yes.
I guess the important part is that we had already had our title study, and we're seeking bank financing, and the bank is outsourcing to this firm to do the title search for them. This was not contracted on our behalf. This was contracted on Scotiabank's behalf. And
I'm sorry, who paid for this title search here?
Scotiabank.
Okay,
Yeah.
please go ahead.
Yeah. So when we talked to Osorio Moreno, I think that's her name. I only talked to her once. She said, well, the thing is, because I asked the same question, and she says, the thing is that, you know, we were only required to do a 10-year title search, but banks are particular about reputational damage. And she says, you know, we go back 20 years because the banks ask us to go back 20 years because they don't have to suffer any reputational damage. That it's not about a legal issue, it's about covering their bases on potential reputational issues. Obviously, if a bank gets mirrored in bad press, it's irrelevant if they actually win some case of EDD. they don't want to be involved. That was the explanation that she gave to me.
This didn't give you the idea to go back to your lawyers and to ask them, well, the bank said it would be more prudent to go back 20 years. Could you do that for me also?
Well, no. The other thing is that this was in 2000 and this was the end of 2015. Our due diligence had already been done. Due diligence was a snapshot in the moment in time. We wouldn't even be able to redo the due diligence first off, and then second off, we had a ton of other due diligence that we had done. We had these Fiscalia study, which was ordered by Corfi Colombiana, that went back 65 years. We felt pretty confident. We felt pretty confident that we were protected under the law and that we had done more than sufficient due diligence.
Okay, thank you. Let's have the morning break now. 15 minutes, meaning we will resume at 12:15.
Mr. President, can the witness be admonished, please?
Yes, I'm sorry. You're still under testimony, and therefore you should not talk to anybody during the break.
Thank you.
we can start. That's fine.
Then let's resume, please.
Thank you, Mr. President. Mr. Seda, we're being asked by the court reporter and the translators to make a pause between our respective question and answer so that they can pick it up. So I will wait after you've spoken, and please wait after I've spoken. as
Sorry
well.
about that.
You just did what I asked you not to do, so let's pause in between. Thank you very much. So you referred, before we went to the break, you referred to the, I don't know how you call it, the certification. You know our position, of course. You were here yesterday. You call it the certification or a certificate of legality or clean title. And what this is, as we explain, is that it's a response by the Fiscalia to whoever is asking, using the right of petition. So you refer to the response provided by the Fiscalia to Corfi Colombiana. I want to show it to you now. It's not in your binder, but my colleague will now give it to you. It can go, we have one tab spare, so it can go under tab 45. And it's for the record, it's C32 bis. You should have both the English and the Spanish version. So it's dated 17 September 2013. And so what we see is that on the first page, it's a response provided to Mr. Cintura, the Corfi Colombiana lawyer, right?
Correct.
Thank you. And it says, so the first paragraph, you see what the request is. I'm pleased to provide you with the response offered by the National Prosecutor's Office through the publication number, etc., in response to the request raised by my office aimed at establishing whether in relation to the property identified as real estate file number, there's a number, of the Registry Office of Public Instruments of Medellin, or in relation to its former and current holder, plural, the National Anti-Money Laundering and Asset Forfeiture Unit carried out an investigation of money laundering and or extinction of ownership proceeding. As can be seen in the attached document, there is no evidence of any type of investigation related to this property or its owners in the database of that unit, right? So this is what you refer to when you say the Fiscalia itself gave a certificate that the title was clean, right?
That's correct.
Okay. So if we go to the next page, so it was SP1, SP2. You see that the response, so it says subject matter right of petition response, right? And it says, with the purpose of responding to the referenced request, I hereby state the following. And it then says, having consulted the Consolidated System of Information this unit manages, to date, there is no record of the people or entities listed below. So when it says to date, this means 9 September 2013, right? This is as of 9 September 2013, correct?
Yeah, as of the date of due diligence, yeah.
Right. And then you see there's a list, and this is the list that was provided by Corfi Colombiana, right? And they take the list and they say for each of the names and companies listed, if they have observations or not, correct?
What is the question?
That they take the list provided by Corfi Colombiana, and for the list provided, for each name or each entity, they then say if they have observations. That's what we see on the table. Right.
My understanding is that is more or less how it's done.
Well, they are being asked to provide responses to a list. So this is the list that they have in front of them, right? So if we look at the next page, we see that there's a reference to Sebastian Lopez, right in the middle. This is the son of Ivan Lopez, right?
Correct. Well,
And-
I assume. Yes.
Well, You discuss him in your statement.
Yes, after all of the investigations and newspaper articles, yes, I assume it's his son. Yeah.
And on the last page, there's a reference on the penultimate box, Inversiones 9 S.A. Corporation. That is the name previously known as Sierra, the company of Mr. Ivan Lopez. You're familiar with that? Sierra Alta.
Yeah, that company rings a bell. Yes.
So what they're asked to do essentially is to provide and to give an answer on the list. It's an exhaustive list. And this list that we see, it doesn't say Sierra Alta, it doesn't say Ivan Lopez, right?
Was the company Sierra Alta, its name changed?
Yes.
So it changed to Inversiones 9, right?
Well, you tell me.
I,
What's your understanding?
I don't know. I'm not
Yes.
I'm not a title study professional. I'm just
No,
asking you a
neither
question.
am I.
Yeah. So again, with that, taking that into consideration, I mean, I think this document for me stands on its own.
No, that's what I said earlier. This is.
I don't wanna try to
There was a
dissect
change
it.
of. We're not going to talk over.
Oh.
There is a change of name, so Inversiones is the former Sierra Alta, right? So, the Fiscalia, when they respond, there's two limitations in their response. One, they're responding only to this list. This list doesn't say Ivan Lopez, and it doesn't say Sierra Alta. They're not doing a corporate search. They're looking at their files and whether there's anything in their files in relation to the entities, and they say, on these entities, we have nothing, right? And then they say to date. That's as of 9 September. So that's what they say, right?
Correct. That's what it says. The document says. Correct.
Yeah, so when you say that you were very comfortable because everything was confirming that the title was clean, every time you see that there's limitations. There's answers provided to certain questions. Is Corfi Colombiana defining the list? And there's disclaimers, as we saw in the second lawyer, in the Osorio, right? So the due diligence requires that there's something going beyond, right? That's the purpose of due diligence, right?
Can I answer your first? Well, I thought your question is, was I comfortable with what exactly is the question?
The question is, when you have documents that have disclaimers or have limitations, by definition it means that you have either to double check or to renew. If they say to date, that is as of 2013. It may well be that something changes later. When Osorio says that they do not have the language, please, they have not looked at the asset for future processes not yet recorded on the deed of title, that means that that's the status at the time. So due diligence means that you have to update, double check, and make sure that due diligence is conducted fully, correct?
So I think I have to answer this question in two parts because I think there's almost two questions. Okay. So I think we have a difference of opinion with regards to what is required with due diligence. I'd like to put out a disclaimer. I'm not a title expert. This is not what I do. My expertise is understanding real estate, understanding what consumers want, what the right thing is to do, the right property, project, hotel, etc. When it comes to technical issues such as this, engineering, title studies, I rely on the professionals that we hire. With that said, my understanding is title research is a snapshot in time. Okay, we signed a contract which bound us to acquire this property, barring that after we had done our title research, that we didn't find any issues, and we did this with good faith and with good conscience, and we did that in 2013. And I hired the most premier companies, financial institutions, banks to do this research for us. And we went as far as writing the Attorney General's office to ask them. So I looked at the universe of all of these pieces of evidence, and I said, I feel great. I feel comfortable. It was not my intention to request to Corte Colombiana to even ask for this 65-year certificate or whatever we'd like to call it. But it definitely made me feel good at the end of the day when I got it. I was very proud of it. I didn't know any other projects that had this. So what you're referencing in regards to shouldn't I have kept doing title research, I don't know. That it kind of brings about a question to me that, well, then that concerns me on the legitimacy of any title. If you buy your home, are you doing title research every year? And if you find something in the future, does it mean you lose your home? My understanding of the law is my limited understanding of the law is no. Is that a bona fide good faith buyer is you look at things at a moment in time, you get comfort with everything, the world of going more and beyond, as you said, which I feel that we strongly did. And then you move on and you hire your architect and you build the beautiful home that you want to live in with your significant other or whoever that is, and you move on. You don't do an annual title study, as you're mentioning, to do continued research to see if you find something in the future. That's my understanding.
So you answering a question I did not ask. I did not say or ask whether the due diligence has to be renewed every year. That's not the question. There's two questions. Question one, when you are asking, either directly or indirectly, a title study, this is important, right? This goes to the validity of the transaction and whether you can continue and build the parcel, correct?
And I greatly apologize. Please repeat the question one more time for me.
The exercise is an important exercise. Title study determines the ability afterwards to proceed with the building and the construction, right? This is you're in a project. You want to make sure that your project moves on good basis, right?
It's an important step to do exactly what the law says. Do the steps that are taken for you to create protection under the law to be a bona fide or qualified good faith buyer without fault. It's if you don't do those steps, well, then you don't create that protection.
Right, but it's an important step, right? In your line of business, it's a very important step.
Yes.
So due diligence as a result is a very important milestone in that process, right?
I agree with you.
So question one, when you said earlier in response to the president's question that you sat down at the time with the Osorio lawyers, went through the findings with them, this means that you can, and even though they were retained, as you say, by Colpatria, you always have the ability to sit down and double check and make sure and get comfortable on the due diligence, correct?
I don't know if you're referencing that you have time to get comfortable or time to get uncomfortable. Because again, the time, the way I understand the law, the way individuals rely on the law is, you gentlemen, I don't know if you own homes or you don't, you go and you buy a home 5 years ago and you hire a company. Well, I don't know if you guys actually read the title reports yourself. I normally don't go that much into detail on, I look at the conclusion. But you buy a home 5 years ago, you receive a favorable title research report, you receive another one, you hire a bank, you receive a favorable report from them or finding, you run it through an escrow or a fiduciary, that comes out favorable, and you're in the middle 5 years down the road and you decide to build a pool. if someone comes and says something, I don't think that you stop building the pool because someone says 20 years ago, I lived in that house and I was displaced from that home, and if that's what you're getting at, I'm not sure exactly what you're getting at, but I definitely say we don't agree on when you're supposed to do due diligence. My understanding of the law is due diligence is done at the acquisition of the property, on the onset of the acquisition, and any diligence done after the fact, the way I understand the law, is useless. I believe the law pretty much states is you can't do due diligence after you acquire a property and have it serve you and do good for you.
So if new circumstances arise, you don't have to update your due diligence, for example.
Again, I'm not an expert on the law, but my understanding is no.
So and thank you for the full narrative and monologue. I will ask you to be shorter, even if you want to give context, because again, we don't have the time. So my question went to the time at which this due diligence was conducted. So when you sat down with Osorio for a purpose, right? You wanted to make sure that they had done what they were supposed to do, correct?
I never sat down with Osorio and Palacio.
That was my understanding when
No.
you answered the tribunal. At the time, I discussed with them. How did you discuss with them?
Are we talking about Ortero y Palacio or Osorio Moreno?
Osorio.
Oh, okay. So, again, you said at the time of the acquisition of the property or the time of the...
At the time of the due diligence, this I understand was your testimony earlier. That at the time when the study was done in 2016, you had discussions with them, right? That's what you said.
To be clear, the title research that we're talking about was not due diligence for title research for the acquisition of the property. This was not title research that was contracted by us. This was title research that was contracted by an entity, Scotiabank, that was interested in financing the property, the project. So, for example, if I had bought this property 40 years before, yet I want to get financing today, even though I've already bought the property 40 years ago, the bank would still run title research today for their own requirements under federal law.
So when you say that you were comfortable with all of the certifications and title studies and all of the comfort that you received, now you're saying that the only due diligence that mattered was the one that you commissioned to Otero? Is that what you're saying?
No, that's not what I'm saying.
So which due diligence was the right one then?
The due diligence, the way I understand the law, for example, my understanding is a bank or a financial entity, they have their own internal processes. We, Royal Property Group or Newport, we don't have those systems. And so what we do is we hire the individuals that do have those systems. So the due diligence that I did, or let's say that I did in representation of our investors, was to hire a prominent, well-known title research firm and tell them to please research the title, whether it was however many years it was going to be. They're the professionals. I relied on their professionalism and their knowledge. We hired a premier, what we thought is the best fiduciary in the country, owned by the largest financial conglomerate, 50,000 employees, and they did their processes. They recommended writing to the Attorney General's office as part of that package of due diligence that we're discussing now, that I relied on, and I was shocked. I didn't even know you could do that. And when we got the conclusion back, it made me feel very comfortable.
So it's not clear what you say.
I apologize. Let me just finish the last thing.
I will ask that you give short answers.
So what I relied on, to get to the point, is I relied on the combination of all of those elements. That's what I relied on for my due diligence.
So you're a moving target, right? If you say, I'm relying on all of that universe, and then I show you the one asked, it's not a due diligence, it's the petition by Coffee Colombiana to the Fiscalia, you say, but this is Coffee Colombiana. If we discuss the Osorio one, you say this is Colpatria. So, which are you referring to? Your due diligence, the one that you commissioned, was the Palacio, right? Otero and Palacio. That was the one that you commissioned in 2013.
So I think, as we know, we were under contract to purchase the property, but the acquirer of the property is Corfi Colombiana. So they're doing the due diligence that's required by them, and I am relying on them doing that due diligence. So I have a reliance on that they're going to do that work right. They're going to acquire the property. The property is going to get deposited into a trust structure. So they have to do it. They have to do it.
Let's
So I'm
take
relying
now
on
the
that.
3 documents we've seen. Otero and Palacio, they do a 10-year search. They have no disclaimer. They just look at OFAC and Google, and they say, I haven't seen anything. Osorio, they actually do see the deed of 94, which is purchased by Mr. Lopez Vanegas. They have that disclaimer that says, we have not looked at asset for future proceedings, not yet recorded on the deed of file. And then we have the petition to the Fiscalia in 2013, I'm going back in time, right? Where Coffee Colombiana gives a list to the Fiscalia, and the Fiscalia responds, as of the time, 9 September, this is what I have, and what I have is a response to Coffee Colombiana on the list that Coffee Colombiana gave, right? I'm just establishing what was seen at the time. We agree on that, right?
At the time is 2013. So the problem
Yes.
is you're adding in a document from a lapse of time, not at the time. What I'm referring to, what we relied on to be to apply and be protected by the law as qualified good faith buyers was the diligence, the realm and world of diligence that we did at the time of acquisition of the property. Those items are: 1, the study by Ortero y Palacio that we contracted; 2, the petition certificate, whatever we will call it, that was positive, that received a positive response from the Attorney General's office, money laundering and asset forfeiture unit. Number 3, the hiring of a nationally recognized fiduciary that had strict guidelines under the banking and finance superintendency, and which we knew, even though we hadn't necessarily seen their manuals because they're proprietary and they're in-house documents, we know that they have to do this because it's regulated by law, that they have to scrub not just the property, but the counterparty for who we're dealing with. That's not just the asset itself, but La Palma, the counterparty who we're buying it from. And so, considering that they're extremely well-to-do professionals, all of those elements that I just described to you there, those 3 elements, gave us a high level of certainty and comfort that we were doing what was right, what was required by the law.
So there were 2 2013 documents, right? One from Otero y Palacio, that's the title study that you asked. One is the petition by Corfi Colombiana to the Fiscalia with the limitations that we saw. And another one later in time for Colpatria in 2016 is the Osario one, right? Which with also the disclaimer that we saw, right?
Yeah, I just want to be clear that
I think we're now turning in circles because the 3 elements that Mr. Seda mentioned did not include the 2016 study, but the fact that they...
I do not know what is his third element.
Well, I think he was clear on that.
What is
sorry.
your third element?
the third element, while we did not receive a report, was the mere hiring of a federally regulated financial institution which had impacted guidelines and regulations which require it by law to run KYC. The same
So
as
the
if you...
fact of having Corfi Colombiana.
Please let me
The
just...
fact of having Corfi Colombiana.
Please
right?
let me just finish.
I would like to have shorter answers.
Sure.
You're having very long monologues. So the fact of having Corfi Colombiana, I'm trying to establish, Mr. Arbitrator, what we're talking about. So it's the 2 documents we saw and the fact of hiring for Corfi Colombiana. That's what gave you comfort. That's your testimony.
having hired Corte Colombiana.
Right.
Yes.
And then you do rely later in 2016 on that title study, because you refer in your statement to multiple title studies, right? These are the two title studies that we've seen. This is the second one in 2016, right?
So I'm not relying on the title study. I'm merely drawing your attention to the fact that this title study, the project Quartier, which we discussed, and I could go through a list of, I don't know, maybe 5, 6, 7, 8, 10 other financial institutions that have all run diligence on Mr. Ivan Lopez, and not a single one has ever had a negative finding with regards to this gentleman.
We'll come back
So
to that, Mr.
so I'm not relying on
Well,
the
you
title
are.
study.
Paragraph
well, you are, but
88. Paragraph
I'm not
88,
relying.
Mr. Seda. Paragraph 88 of your statement, number 1, which I quoted earlier, that's in the context of your discussions with Mr. Mosquera and Ivan Lopez. Newport had transacted in good faith and extensive due diligence had been done on the properties, included 4 title studies and a certification from the Fiscalia. So you are relying on the title studies, right? And that includes Osorio.
I said 4 title studies.
Okay? But this is one of them.
This is not one of them.
What are the 3 others then, if it's Otero?
So
Because you don't mention anything.
we performed an in-house title study, which we always do. I had my in-house legal counsel, so we don't waste money. The first thing we do whenever we're gonna go into a purchase and sale acquisition is, rather than hire an expensive law firm to do a title study, we do an in-house title study. That's important for us.
Is that title study on the file?
No,
in-house study?
it's an informal title study that we do in-house. So we'll have our in-house counsel. We'll say, please review the title, look at it, make sure it's okay. Once I get the word back that it's okay, then we go, okay, now let's hire a law firm that's going to do this extensive review.
So we do not have that on record, right?
No, we do not have that on record.
And how did you conduct that due diligence? Was it a Google search? How did you do that?
Well, I gave it to our in-house counsel, and he did whatever I assume is his policy and processes. The same, I think, is that we performed, for example, a title study on Charlie, and I think Luxe. Charlie, we then subbed out and had a title study done after the fact. Luxe, I don't remember if we relied on our own or if we relied on the fiduciaries. I don't remember.
And of course, we don't have the benefit of that, but we have the benefit of another title study, which is not in relation to Meritage. I would like you to look at Exhibit C144, that's tab 15. And this is a title study by the law firm Rodriguez Azuero, right? Regarding the land for your project in Santa Fe de Antioquia, right?
That's correct.
And it's dated November 30, 2015, as you see. So, if we look at the first page, they say how they do it, right? It's a bit different from those that we've seen so far. This study is based on the legal verification or analysis of the legal situation and background of the premises, obtained from data extracted from the property's public registry and from the analysis of the acquisition titles thereof. The study accomplished with regard to the background title situation of the premises includes the last 20 years, since any anomaly evidenced before such term would not affect the legal situation of such properties, given that should a cause of action arise based on an act entered into or occurred prior to such term, is bound to be objected, adducing the status of limitations to defend the current legal situation of the plots. So they explained the process, and here we see that they do 20 years, right? In relation to this property, right?
That's what the document says, correct?
You remember this document?
Yeah, vaguely, but yes, I remember it. I reviewed it, yes.
And if we look at the next page, and they actually have a disclaimer, or what they call here in the English version, reservation, which is much more substantial and substantive than what we had in the Osorio one. So I quote from the page 2, the Land Restitution Civil Division of the Highest Court of Antioquia Judicial District in decision dated 13 February 2014 indicated that the title study does not suffice to infer good faith without fault to acquire premise, and that there should be extremely diligent inquiries regarding the social and political context and the effects caused by the internal armed conflict in order to have certainty that none of the holders of the ownership real right was kicked out or forced to abandon their land, or that any of the grounds described herein below have been configured. And then you see there's a reference to 2 laws. First, there's a victim laws in relation to ownership real rights that have been deprived or forced to abandon. And then you have reference to the Asset Forfeiture Code and the law of 2014, which refers to a number of illegal activities that are listed here. And you finish on that page. Our firm, Rodriguez Azuero Contexto Legal, makes a disclaimer consisting in that the report of the title study hearing submitted reflects all relevant legal acts in the ownership background chain of the premises without having inquired on the occurrence of any of the above stated grounds that may lead to possible asset forfeiture of the premise subject to matter of the study. Right, so my first question is, you see from the reservation, if we go back to the previous page, that sets out the standard for due diligence, and that's based on a judicial decision of February 13, 2014, right? And it says there should be extremely diligent inquiries regarding the social and political context and the effect caused by the internal armed conflict in order to have certainty that none of the holders of the ownership rights was kicked out or forced out, right? That is exactly what Mr. Lopez Vanegas is complaining of, isn't it?
And apologies, I just want to look at the Spanish version. Give
Sure.
me 1 second. Thank you very much. And I apologize. What page is this? What says reservation?
2, the second page.
Second. Salveat. So a few things. I agree. If you look at 20 title searches, they're all going to have different clauses and qualifiers, and they're going to look quite different. Number 2, what this is referring to is not EDD. This is a different law. It's restitution of lands, and it has to do with people being pushed off of lands due to the armed conflict, and it is a huge problem that's occurring in Colombia. A huge issue.
But next you have Asset Forfeiture Code, right? That's the second.
And sorry, I just like to make a correction. When I say a huge issue, we're seeing similarly a lot of fraud, a lot of people coming back 50, 60, 70 years after the fact and saying, I want to take that land back. And so, yeah, of course, attorneys they're very cautious, they're very careful, because as I think you guys mentioned yesterday, you could even go back 20 years, but apparently you're saying that even that's not enough. It's not prescribable, the law. So
My question again is, if you look at reservation, it's not what the lawyer said. The lawyers indeed have this disclaimer saying what they have not and will not certify. What's important here is that it's the standard of due diligence, and it's based on a judicial decision of 14, where it says that title studies should be there should be extremely diligent inquiries into the social and political context and effect caused by the internal armed conflict. So this is a very high threshold. You have to, when you do due diligence, it's not enough to just go through a list of names and stop there, or to limit yourself to a number of years, 10 years, when you may have something beyond. You actually have to be extremely diligent. And the reason for that is the social and political context and effects caused by internal armed conflict. This is the context we're talking about. We're not in France, we're in Colombia, Medellin, right?
Yes, we're in Colombia.
So the high threshold you were familiar with, right? You by definition, if you do so many title studies here for Antioquia, you know what the standard is, right?
If your question is when this title study was done in November 2015, if I remember this paragraph, to be completely honest with you, no, I didn't read this specific paragraph. I ordered the title study, like many title studies in the past, look over it briefly, get to the conclusion section, see that it's favorable, trust that the professionals I'm hiring know what they're doing, they're top caliber, and that gives me comfort.
Potentially having discussion with them when they give disclaimers such as this?
I just said, I do not remember reading this specific paragraph.
No, I'm asking you what the process is for you. You do not discuss with them, or do you discuss with them? Do you, when you have a law firm saying, I'm doing this title study, but you have to be, the standard is extremely diligent, nobody brings it up to you, even if you don't read, nobody tells you this is serious, we have to be extremely diligent, so we have to go beyond normal circumstances?
I can affirm to you as a matter of fact, when this law firm, Rodriguez Acero, Contexto Legal, performed this work and gave us this title study, not a single person came and said, here's this title study, but I would like to add a qualifier to this. This is, and said any of the things that you said. This thing was sent to us via email. I called the attorney and I said, so all is good? And he says, yeah, title came back great, clean.
And you don't look at the standard and you don't look at the disclaimer. There is a disclaimer about assets for future proceedings.
So I also don't look at, when I get an engineering report, I don't rerun the calcs. I wouldn't even understand how to do it. Okay. I call the attorney. I said, I got the title study. Is it good? Are we good on title? And the attorney says, yeah, ran the title. It's good. We're good to go. And that makes me comfortable.
The question is not you personally, Mr. Seda. The question is your company. It's the process through which you collectively go. So whether or not, if you're not satisfied and fully rely on a lawyer, your lawyer should do that. And your lawyer should be familiar with disclaimers and standards established by court decisions. Right? So this is, as we agreed, this is an extremely important milestone when you acquire a land in Medellin, in Colombia, against the background of drug trafficking and asset for future procedures, which is the law. You know the law when you go to Colombia, right? The law is there. You know that there's asset for future procedures, don't you?
I do know there's assets for future procedures. That's why we hire the professionals to make sure we don't become enshrined in one.
Right. And so if we look at the law, since you raised the limitation issue, that's Exhibit 3 bis, tab 16. And that's the law of 2014 as asset for future. You see Article 21, page 6. Right, so it says prescription. The asset for future action is not barred by statute of limitation. Asset for future shall be declared regardless of whether the grounds for its applicability have occurred prior to the entry into force and effect of this law. This shows, if anything, that it's a very serious matter. If there's no statute of limitation, because it goes to criminal action, correct?
You're asking me to interpret law.
No, I'm asking you if this is a, you say, I don't know if there's a statute of limitation. I'm saying, well, this law says there's no statute of limitation.
Well, I agree that that's what the text says there. I agree that there are individuals that view it that way. I'm not going to try to opine or dissect the law and give you a professional opinion. I think we should leave that to the professionals. I'm not well equipped to do that.
I understand, and that's fair. The question is not whose view it is, it's the objective law. The law says there's no statute of limitation. So my question is, did you know that there's no statute of limitation for assets for future proceedings?
No, before these proceedings, no.
Mr. President, shall I continue? I'm in your hands as to when you want to have the break.
Well, it's close to 1 o'clock. I think we should have our lunch break now.
I think we should have our lunch break now and resume at 2 o'clock.
I'm happy to.
Yeah.
Thank you.
Thank you. Again, please do not talk about the case with anybody during the break.
Thank you.